Hello everyone, and welcome to the Texas Workers' Compensation 101 Comp course. My name is Stephanie Saldaña, and I'm a program specialist with the Texas Department of Insurance Division of Workers' Compensation. Whether you're an injured employee, an employer, an insurance carrier representative, or simply someone looking to better understand the Texas workers' compensation system, you're in the right place. Through this training, we'll explore who the key participants are in a claim, employee, employer, and insurance carrier rights and responsibilities. We'll also take a look at medical and income benefits, the claim process, the dispute resolution process, and resources available to help along the way. Now, our goal is not to make you an expert in every aspect of workers' compensation, but to help you better understand how the system works and where to find assistance when you need it. Thank you so much for being here and taking the time to join us. Let's dive in and get started. For our learning objectives today, we'll look at the Texas workers' compensation system and how it's structured. We'll dive into the roles of the injured employees, the employers, the insurance carriers, what type of income benefits exist, how long they last, and who qualifies for those benefits. We'll get a better understanding of maximum medical improvement and impairment rating. We'll take a look at dispute resolution and get a basic understanding of that process, the importance of compliance, and we'll learn about key Division of Workers' Compensation programs that support employers, employees, and claim participants. Now, my goal is to give you a clear roadmap so you understand the process from the moment that an injured worker sustains an injury and what happens the whole way up to benefit eligibility. Now, in order to do that, let's start with basics. So what is workers' compensation? Well, the Division of Workers' Compensation, or DWC, is part of the Texas Department of Insurance. It is governed by the Texas Workers' Compensation Act found in the Texas Labor Code. Now, our role is to administer the Texas workers' compensation system and to provide resources, education like today, and assistance to employees, employers, insurance carriers, healthcare providers, and other system participants. Throughout today's presentation, I'll share information and resources that are designed to help participants better understand workers' compensation process and the available benefits out there. Now, workers' compensation is a state-regulated insurance program that provides insurance coverage to employees who get hurt or get sick because of their job. Now, it does pay for medical care, pays for part of lost wages, and other benefits in some cases. Some of these other benefits may be death benefits. Death benefits are benefits that are paid to dependent when a worker dies from a job-related injury or illness. It also helps workers recover and return to work, and it protects employers from most workplace injury lawsuits. Now, the goal here is to protect workers and their families financially while keeping costs predictable for employers. And it's governed by the Texas law, Texas Labor Code, and Texas Administrative Code. And so who participates in a workers' compensation claim? Well, in a workers' compensation claim, we have the injured employee or beneficiary in some cases, an employer, and we actually have a whole CompCourse webinar that focuses on employer rights and responsibilities in the system, the insurance carriers, the Division of Workers' Compensation, and healthcare providers, such as a treating doctor, which is the treating doctor providing the initial medical treatment to an injured employee, designated doctors known as DDs, which are state-selected doctors, required medical exam doctors, known as RME, which are insurance carrier selected doctors. Now, if you want to learn a little more about the doctors and their roles in our system, we also have a CompCourse webinar on that too. And now that we know who participates in a claim, let's look at how the claim generally moves from start to finish. A worker compensation claim starts when an injury or illness is reported by the injured worker. Now, the injured worker generally reports the claim to the employer, and the injured worker must do so within 30 days from the date they knew that they were hurt or from the date they knew that their injury or illness is work-related. Now, the employer must report the injury by filing a DWC Form 001, which is an employer's first report of injury or illness, and must do so within 8 days
from the day that they know that the employee is unable to work for more than one day due to the injury, or immediately if the injury is a work-related disease or death. Now, the injured worker must also file a DWC Form 041, which is an employee's claim for compensation for a work-related injury or occupational disease. Now, this form must be filed by the injured worker with the Division of Workers' Compensation within 1 year. Now, by this time, medical treatment has or will initiate while the insurance carrier is administering the claim. Now, the insurance carrier will, of course, be ensuring that the injured employee is receiving reasonable and necessary care and may initiate income benefits if the injured worker is eligible for them. Now, during this time, the injured worker is also treating with their treating doctor and healing in an attempt to return to work. Now, the treating doctor would be in charge of filing the DWC Form 073, which is a work status report providing all parties in the claim a status of the injured worker's work status. Now, during this claim journey, there may be possible issues. Now, these possible issues may arise a dispute, and this is where the dispute resolution process may initiate if needed. Now, if there's a dispute issue, any party on the claim may file a DWC Form 45, which is a request to schedule, reschedule, or cancel a benefit review conference. Now, there may be other issues as well that may require a dispute, and there are other forms that may be filed to do so. Now, the attempt and the goal is to reach a claim resolution for the injured worker and all parties involved in the claim. Now, for more information specifically on a dispute resolution, we do actually have a CompCourse online that focuses specifically on that.
Medical benefits. So let's take a look at medical benefits and a basic overview of them in a claim and in the process. Injured employees have the right to choose their treating doctor. Now, medical benefits provide treatment for work-related injuries and illness to help employees recover and return to work safely. No out-of-pocket costs for approved treatment. And some of this medical treatment may include doctor visits, diagnostic testing, such as x-rays, MRIs, in addition to therapy, such as physical therapy and rehabilitation therapy. There are other services as well that injured workers may obtain, and they may be covered as well, which are emergency care, prescription medications, surgeries, and hospitalizations, all when medically necessary. Now, network rules may apply. Some claims are in-network, some are out-of-network. But if a claim is in a network, then that means that generally the medical treatment that the injured worker receives must be obtained within that network. As far as the medical treatment process, treating doctors guide care and return to work recommendations. Now, referrals to specialists may be made when they're medically necessary, and some services may require pre-authorization under treatment guidelines. Now, approved medical providers bill the insurance carriers. Now, DWC's goals is to ensure that participants understand their rights and responsibilities through the workers' compensation claim process. Beginning with employees. Now, employees have rights. Employees in Texas have the right to retain their common law right to sue their employer. When hired, employees must be provided with a new employee notice. Now, employees have 5 days from the date of hire to reject coverage if they choose to. Now, employees who reject coverage must do so in writing and can't obtain income or medical benefits related to the injury. Now, employees also have the right to receive the income benefits if they're due. Employees have the right to receive medical care for their work-related injury as long as it's reasonable, necessary, and related to the work-related injury. Employees have the right to get help from the Office of Injured Employee Counsel. If there is an issue with the claim and the employee feels that they don't agree with a certain outcome, the Office of Injured Employee Counsel, also known as OIC, can help them for free. Now, employees also have the right to dispute resolution, which is the ability to represent their case when there's a disagreement between them and the insurance carrier. And employees have the right to hire an attorney to represent them for their case as well. Now, employees have the right to have their claim information be kept confidential, and employees have the right to choose who their treating doctor is. Now, if an injured employee is in a network, injured employees must choose the doctor from the network's treating doctor list. And just like rights, employees do also have responsibilities. As part of the employee responsibilities, employees must tell their employer when they've had an injury or they've been diagnosed with an occupational disease. Now, they do have 30 days to make that report to their employers. Now, employees must also fill out an employee's claim for compensation work-related injury or occupational disease. This is a form known as the DWC Form 41. And employees have 1 year from the date of injury to file that form with the Division of Workers' Compensation. Now, employees must also let the division know and the insurance carrier whenever there are any changes in their pay or in their work status. It is very important that any changes are reported. Now, employees must explain to their treating doctor how the injury happened, and employees must let the Division of Workers' Compensation and the insurance carrier know how to get a hold of them. Keeping the contact information current is extremely important as well. Now, employees must follow their network rules. Again, if they are in a certified network, employees should ask their employer if they're in a certified network and choose a doctor and obtain medical treatment within that network. There are injured workers who are first responders. And so who is a first responder? Now, first responders may be identified as peace officers, paramedics, firefighters, detention officers, county jailers, or emergency medical service employees. These typically work for a political subdivision in Texas, like a city, a county, or a school district. Now, if the first responder is a volunteer first responder, they should ask their manager or place of employment if they have workers' compensation. First responders also have the right to expedited medical health care service benefits, expedited dispute resolution, and certain diseases may be presumed work-related under Texas Government Code Chapter 607. Now, some of these specific job-related diseases may be, for example, specific cancers, infectious disease, heart attack, stroke. In addition to that, a spouse that married a first responder on or after September 1st of 2017 can actually get death benefits for life even if they remarry. And in addition, for first responders, there are DWC single point of contacts that are assigned to first responder claims that help them navigate their workers' compensation claim and receive one-on-one help as well. Now, employers also have rights, and of course, as an employer, they have the right to choose who they carry workers' compensation with. Now, they have insurance carrier options, and they get to choose who the insurance carrier is. Now, employers do have the right to contest compensability of a claim, meaning that if they don't agree with the insurance carrier's decision to accept a claim, they can actually request a hearing to dispute it. Now, employers also have the right to be notified of any dispute resolutions proceedings, and they must send a written notice to the insurance carrier requesting to be notified. Now, employers also have the right to attend any dispute resolution proceeding and even be present if evidence is appropriate. Now, employers should always report fraud to the Division Workers' Compensation if they suspect fraud or identify fraud. Employers also have the right to receive return to work services. So employers can contact the Division of Workers' Compensation to let us know that their insurance carrier isn't providing accident prevention services. Now, licensed insurance carriers are required to maintain or provide services. These services include surveys, consultation recommendations, training, analysis of accident causes, industrial hygiene, and industrial health services. And so based on the nature of the policyholder's operations, failure to do so could be a compliance issue for the insurance carrier. In addition, employers can also receive return to work coordination services from their insurance carrier and from the Division of Workers' Compensation. Now, services from the Division of Workers' Compensation include return to work consultation workshops, training by the Division of Workers' Compensation, return to work employer guide that can be downloaded from our website, return to work reimbursement program. And for that information, we'll be discussing at the end and letting you know where you can find these resources as an employer. Now, for employer responsibilities, employers must tell their employees that they carry workers' compensation insurance, and they must do so by providing written notice of coverage to the new employees upon hire. Now, this notice must inform the injured employee of their right to reject workers' compensation and retain their own common law right of action. Now, the notice must be in the wording and format prescribed by the Division of Workers' Compensation. Now, employers must report injuries to the insurance carrier within 8 days from the day of. The injury results in the employee losing time from work for more than 1 day, that the employee has been diagnosed with an occupational disease, or that the employee has suffered a fatality. And a written copy of the report should be provided to the injured worker at the time that the report is made to the insurance carrier. Now, employers are also required to report wages. They do so by filing an employer's wage statement, which is a DWC Form 003, and the employer has 30 days to file this form with the insurance company. Now, employers must also report any changes in the employee's wages or employment status. Now, they must report it to the insurance carrier, and they must do so using a DWC Form 006, which is Supplemental Report of Injury. A copy of the Supplemental Report of Injury must be provided to the injured employee as well. Now, as employer responsibilities as well, employers are required to file forms timely. They are also required to post written notices in a workplace area, Notice 6, which also must be in the wording and format prescribed by the Division of Workers' Compensation. These notices must be updated if there are any changes. Now, employers have to keep records of these reports for 5 years or according to OSHA standards, whichever is longer. And employers who are non-subscribers and have more than 5 employees must also report injuries and fatalities. This is done by using a DWC Form 007, which is an employer's report of non-covered employees' occupational injury or disease. Now, employers must cooperate with Division of Workers' Compensation audit and investigations, and, of course, provide a safe workplace for their employees. Now that we've covered what employees and employers must do, let's take a moment to talk about what insurance carriers' rights and responsibilities are as well. Now, carriers have several rights within the system as well that help them verify claims and ensure that benefits are paid correctly. Now, carriers, they can investigate the claim thoroughly, they can request medical records and dispute parts of a claim if something doesn't match the medical evidence. They can also request a designated doctor or a required medical exam when clarification is needed. And just like any other party in this system, the insurance carriers do have the right to appeal decisions through the dispute resolution process. Now, understanding these rights help everyone know what to expect during a claim. And for their responsibilities as an insurance carrier, well, insurance carrier need to make sure that they process claims according to the Texas law, that they pay benefits when they are due, that they issue the necessary notices when needed, that they communicate claim decisions, and they coordinate medical and benefit-related services. Now, insurance carriers' responsibilities are also to participate in dispute resolution process. And now let's take a closer look at the different type of income benefits that may be available through a claim.
But before we do that, let's talk about disability and workers' compensation. Now, disability and workers' compensation does have a specific meaning. Disability means the inability to earn pre-injury wages because of a compensable injury. Now, it is required for eligibility for many income benefits that we will be discussing shortly. And it does not mean that the injured employee has to have a physical injury or medical condition. And it is very different from Social Security disability that it often gets confused with. Now, let's take a look at some examples just to gain a better understanding. Now, both of these employees have suffered a work-related injury. One employee has a neck injury, and the other one uses a wheelchair following their injury. Now, at a first glance, many people would assume that they automatically have a disability under workers' compensation. Now, if these employees are able to return to work and earn the same wages that they earned before their injury, they may not meet the workers' compensation definition for disability. Now, this is an important distinction. An employee can have a permanent injury, ongoing pain, or physical restrictions and still not meet the workers' compensation definition of disability. Now, if they are able to earn their pre-injury wages, they may not meet the definition of disability. Now, let's take a look at another example of what disability may look in the Texas workers' compensation system. Now, here we have an example of two employees who suffered a work related injury and are recovering at home. Now, because of the injury, these injured employees are unable to return to work and are not earning the wages that they earned before the injury. Now, under the Texas Workers' Compensation Act, these employees have a disability because the compensable injury has affected their ability to earn their pre injury wages. This is exactly the type of situation temporary income benefits are designed to address. Now, these benefits can help replace a portion of an injured employee's lost wages while they recover or are unable to return to earning their full pre injury income. Now, it is important to remember that the focus isn't simply on the injury itself. The key question is whether the injury is preventing the employee from earning the wages they were earning before the injury. Now that we understand what disability is, now let's go ahead and discuss what income benefits are.
Income benefits are designed to replace a portion of an injured employee's lost wages when work-related injury impacts their ability to earn income. Now, depending on the circumstances of a claim, an employee may receive different types of income benefits at different stages of recovery. Some of the type of income benefits that an injured worker may receive during the life of a claim are temporary income benefits, impairment income benefits, supplemental income benefits, lifetime income benefits, death and burial benefits. Now, starting with temporary income benefits or TIPS. These are often the first income benefits that an injured employee may receive. Now, temporary income benefits are intended to replace a portion of lost wages when a compensable injury or illness prevents an injured employee from earning pre-injury wages. Now, in order to qualify, the employee must lose earnings for more than 7 days due to the injury. Now, benefits are generally paid weekly, and they are calculated based on the difference between the employee's average weekly wage and any wages earned after the injury. Now, temporary income benefits typically end when an employee returns to earning their pre-injury wages, reaches maximum medical improvement, or reaches the applicable statutory duration limit. And so let me explain a little bit of what is maximum medical improvement. Maximum medical improvement is a point when an injured employee's condition has stabilized. Now, additional medical treatment is not expected to significantly improve the injured employee's condition. It does not necessarily mean that the injured worker has fully recovered, but it may mark the end of temporary income benefits. It is an important milestone in a workers' compensation claim, and it helps determine eligibility for future income benefits. Now, this may also lead to the assignment of an impairment rating. An impairment rating is assigned after an employee reaches maximum medical improvement. Now, it is also a percentage that represents permanent impairment resulting from a work-related injury, and it's based on medical findings and established guidelines. Now, it is assessed as a percentage, so for example, 4%, 13%, 20%, and it helps measure the lasting effects of an injury. Now, it does determine the duration of impairment income benefits, which we'll cover in a little bit, and it may affect the eligibility of supplemental income benefits. And impairment income benefits. Well, impairment income benefits begin after maximum medical improvement is reached. Injured employee must have an impairment rating in order to be paid impairment income benefits. These benefits are paid weekly, and they are paid 3 weeks of benefits per each percentage point received. Now, the duration is based on the impairment rating, and disability is not required in order for an injured employee to receive their impairment income benefits. And we also have supplemental income benefits, or SIBs. Now, these supplemental income benefits may be available after impairment income benefits end. Unlike other income benefits, not everyone qualifies for supplemental income benefits. In order to be eligible, an injured employee must generally have an impairment rating of at least 15%, and they must also meet additional statutory requirements. Now, the eligibility is reviewed every quarter, meaning that employees must continue to demonstrate that they qualify for these benefits. Injured employees would have to apply every 3 months for these type of supplemental income benefits.
The final type of income benefit we'll discuss today is lifetime income benefits. Now, it's often referred to as LIBs. As the name suggests in these type of benefits, these benefits are paid for the lifetime of an injured employee. However, it is very important to understand that lifetime income benefits are not available for every work-related injury. Now, they are reserved for the most severe and catastrophic injuries identified in Texas law, which I will be discussing shortly. And unlike temporary income benefits, impairment income benefits, or supplemental income benefits, the eligibility for lifetime income benefits is actually based on meeting specific statutory requirements rather than simply experiencing a loss of wages. Now, once eligibility has been established for these type of benefits, lifetime income benefits continue for the employee's lifetime and are subject to an annual increase as provided by the law. And while lifetime income benefits are the most long term income benefits available under the Texas Workers' Compensation System, they are also the most limited in terms of who qualifies. So, what types of injuries may qualify an injured employee for lifetime income benefits? Let's take a look at some examples. Now, for these type of benefits, Texas law identifies several catastrophic injuries that may qualify an employee for these benefits. Some of those examples include the total and permanent loss of sight in both eyes, the loss of both feet, the loss of both hands, or the loss of one hand and one foot. Other qualifying injuries may include paralysis, severe traumatic brain injuries, and extensive third-degree burns. Now, these examples actually illustrate just how serious the qualifying injuries must be. Now, lifetime income benefits are intended to provide lifetime financial support to employees whose work-related injuries have resulted in a permanent catastrophic impairment. In order to apply for these type of income benefits, the injured employee must do so in writing with the insurance carrier.
And death and burial benefits is another type of benefit available. Now, these are available when an employee dies because of a work-related injury or illness. Now, the beneficiaries must file a DWC Form 42, which is a claim for workers' compensation death benefits, and must be submitted along with supporting documentation. Now, it does provide financial support for eligible beneficiaries and helps cover funeral and burial expenses. Now, these are paid to beneficiaries like a surviving spouse, minor children, and eligible children, including certain full-time college-enrolled students. Now, they are paid weekly, paid at a rate of 75% of the deceased employee's average weekly wage. Now, benefit duration does depend on beneficiary eligibility. Then we have dispute resolution process. Now, sometimes a claim does not move smoothly because there are certain disagreements between the claim participants. Now, it may be whether the injury is work-related, what the impairment rating is, or what type of benefits the injured employee qualifies for. When that happens, the Division of Workers' Compensation has a dispute resolution process. So it actually starts informally with a benefit review conference. It moves into a contested case hearing if needed, and it can go up to the appeals panel. Now, it is designed to help reach fair decision and keep claims moving smoothly. And so understanding the dispute resolution process, well, it is designed to resolve disagreements related to a claim. Some of the most common indemnity disputes may involve compensability, income benefits, medical issues, maximum medical improvement, and impairment rating. It is a fair and structured process for resolving disagreements and keeping the claims moving forward. And so it usually starts with a benefit review conference, or a BRC. It is a meeting to try to resolve disagreements informally with a benefit review officer. The issue is not resolved at a benefit review conference. It then moves forward to a contested case hearing, where a formal hearing takes place in front of a hearing officer. If either party disagrees with the contested case hearing decision, then they may request it to be reviewed by a WC appeals panel. And finally, in some cases, parties may appeal further and go through the court system, and this is what we call a judicial review. Now, the goal of the dispute resolution process is to resolve disagreements as efficiently as possible while ensuring that all parties have the opportunity to be heard.
Not all disputes in the workers' compensation system involve income benefits or other issue disagreements. Now, some disputes involve medical care, and the two most common disputes involving medical care are medical fee disputes and medical necessity disputes. Now, a medical fee dispute is generally a disagreement about payment for medical services that have already been provided. Now, the medical fee disputes are handled different depending on the network status of a claim. If the claim is a not network claim, these disputes are actually reviewed through the Division of Workers' Compensation Medical Fee Dispute Resolution process, often referred to as MFDR. If the claim is in a certified healthcare network, then they have their own internal process for resolving these disputes. A medical necessity dispute is different. Now, these disputes arise when an insurance carrier denies or questions whether the requested medical treatment is medically necessary. In those cases, the dispute may be reviewed by an independent review organization, or known as the IRO, which uses an independent panel of medical professionals to evaluate these requests. Now, depending on that outcome, additional appeal rights may be available through the Division of Workers' Compensation. The important takeaway is that medical disputes follow a different process than disputes involving income benefits or other type of issues related to a claim.
And compliance. Compliance is another important part of the workers' compensation system and actually supports the entire claim process, the claim journey. Now, the Division of Workers' Compensation monitors reporting, notices, forms, and timelines to make sure that everyone follows the rules. Compliance activities keep the system fair, they prevent delays, and ensure accurate information is shared between all claim participants. Now, compliance's primary goal is to encourage the adherence to requirements to support a fair and effective workers' compensation system. And so they conduct audits and investigations when necessary. They do monitor the reporting requirement and deadlines. They support fair and consistent claim handling. They review required notices and filings. They promote accountability among system participants. They help protect the rights of all parties involved. And they help maintain the integrity of the workers' compensation system. And whilst today's focus was primarily on the claim journey from beginning to end, the Division of Workers' Compensation does offer additional resources that can support participants at various stages of the workers' compensation claim process. Now, some of these additional resources are a lot of educational resources. So we have CompCourses and webinars such as today. These are available on our website. You can actually go in there and replay them. We have forms, notices, and reference materials. So on our website as well, you'll be able to pull up some of these forms and plug it in with your information. There are forms that are available in PDF formats that can be written on, and you can use that for your place of employment. There are safety and return to work resources. So on our website, you'll find these available resources as well, some of the guides that they have available that you're able to use in a PDF format and so forth. Customer assistance and outreach services. So we do have our customer service line that we'll be sharing with you as well shortly, where you can call at any time. We have those available English and Spanish to assist injured workers, employees, representatives, beneficiaries, all claim participants in the workers' compensation system. Now, there are educational publications and guides that are also available. Online videos and recorded presentations can also go in there, and you can view these videos, replay them, share them with others if needed. But these are available on our website as well. And then website tools and services are also available. So there are things like calculators, average weekly wage calculators that can help an insurance carrier find what the average weekly wage is for an injured employee, amongst other tools available out there that can be used as well. And then we have the single point of contacts, known as SPOCs, that provide escalated customer service. They're subject matter experts and can obtain their assistance also by calling our customer service line and letting them know that you're needing assistance. Now, all of these resources you can actually locate on our website, and we do have a QR code where you can go in there and actually look depending on what you're needing. If you're an employer, an employee, an insurance carrier, you can go in there and explore the resources available to you all. Now, additional resources, as mentioned earlier, we have return to work services. Now, while we won't be covering their services in detail today, it is important that participants know that these resources do help support the efficiency of a claim and claim handling and the information management throughout the workers' compensation system. So we'll share some reference QR codes so you can go in there and explore them further. But as far as return to work services, they offer individual consultations. They actually have workshops, seminars, they offer training, and they have a really nice employer resource guide available online with them. And then job safety. Now, job safety has OSHCON, which is the Occupational Safety and Health Consultation Program, which is a free program that actually provides consultative services. Now, this helps Texas businesses make their workplaces safer and prepare for OSHA inspections. Now, they also offer training. So, Workplace Safety actually offers an OSHA 10 and 30-hour course, as well as CPR and first aid training. For those kind of classes and training, you can go in their website. We're also providing a QR code if you're interested and would like to register for any of that. That's available for them as well. They also have job safety assessments. They have accident prevention plans. They offer safety inspections and industrial hygienist service, as well as online resources for them. And how to contact us? Well, we do have a DWC customer service line, both in English and Spanish, designed to help all claim participants. So if you have any questions on today's presentation or anything else, maybe a specific case scenario that you would like further clarification on, you can definitely give us a call at our customer service line. If any escalated customer service is needed, please rest assured that we will make sure that we get you to the right program area or department to further assist you. You can give us a call at 1-800-252-7031, option 1, and one of our customer service agents will be able to assist you. And so for today, some of our highlights for today's presentation. Well, workers' compensation provides medical and income benefits for work-related injury and illness. Now, employers, employees, insurance carriers, and DWC all play important roles throughout the claim process. Understanding rights, responsibilities, and reporting requirements help claims move smoothly. Income benefits vary based on an employee's stage of recovery and eligibility requirements. Maximum medical improvement and impairment rating are important in claim milestones. Now, Division of Workers' Compensation offers dispute resolution services to help resolve disagreements fairly. And compliance supports fair and consistent and effective workers' compensation system. And I will now be answering questions that you may have related to today's presentation. We'll be with you momentarily. Thank you so much for attending today's CompCourse webinar. I really hope that you enjoyed today's course and learned a little bit more about workers' compensation. Just as a reminder for today, you must stay in the Q&A to receive the continuing education credit. Now we will begin with questions from the Q&A tab, so if you can please enter your questions there, and then I'll try to get to everyone's questions. Now, if we don't get to everyone's questions, I'll go ahead and give you some information right now where you can submit those questions, and I will get back with you to provide you those answers. So let's get started. Do you have a few questions in the chat already? All right, so the first question I have up here is, what if an employee doesn't miss any work and they didn't seek care as a result of the incident? Does the employer still report the incident, noting no missed hours and no care requested? What is the time frame for this being submitted by the employer? So that's a great question. So generally, no. So if the injured employee does not miss more than 1 day of work, and there is no occupational disease or no work-related fatality, then what happens is that the employer is not generally required to file the employee's first report of injury or illness at that time. However, it is important that the employer does keep record of the injury and the information, just in case the employee comes back later seeking any medical treatment or begins medical treatment or missing work because of the work-related injury. Now, at that time, just to add on, at that time, yes, the employer would be required to file that report of injury. Now, let me see. Our employees that qualify for workers' comp only apply to W-2 or also 1099. So it applies to both. It's not only for W-2 employees. So W-2 or 1099 employees, workers' compensation doesn't apply. It's not generally for like a specific how they get paid, how they qualify. And so yeah, so W-2 or 1099s, they qualify. Again, for that point, you would have to kind of inquire with the insurance carriers and see what their requirements are to provide that coverage. Kind of shop around for those workers' comp coverages as an employer. Let's see. Is it against the law for a medical facility to bill a personal health insurance if it's a work-related injury? So a healthcare provider should not be billing an injured employee or their personal insurance if they've already identified it's a work-related injury. So the provider should be billing the workers' compensation insurance carrier, not the personal health insurance. Now, there may be situations and questions, so all the claims are different, and there's might be compensability issues that are being disputed, things like that that the healthcare provider may not be aware of, or may not be aware that it's a work-related injury. But no, they should not be billing personal insurances or injured employees if it's been identified as a work-related claim. Mr. Arthur, I do workers' compensation billing and collections for a medical company. Is a license required? To be very honest, I would not be able to answer that question. We don't do any of the deal with any of that licensing and requirements when it comes to medical billing. Um, so I'm not sure what resource we could find for that, but let me see if I can ask around. To be honest, I'm not familiar with that. And then, if employer is self-insured, is it still required to post notice 6? So if an employer is self-insured, yes, they're still required to post notice 6. So this requirement is to notify employees of workers' compensation coverage applies, whether they have coverage or not. So yes, you would still post the notice. And then this notice should be posted where employees can see it, like in a personal office, break room, something like that, where it's visible to employees. Let's see. So it says when you say the employer has to report the claim within 8 days, that is 8 days after the injury is reported, right? Oh, wait, I moved, sorry. 8 days after the injury was reported. Sometimes people report very late. Yes, I understand people do report injuries very late sometimes or later than the required time frame. So yeah, from the time you become aware. So remember, it's from the time that you become aware that the employee loses more than one day because of a work-related injury or illness, or that you as the employer learn of that work-related injury, disease, or fatality. What is the difference between a DD and an RME? So a designated doctor is a state-selected doctor, and these doctors are usually appointed to address different issues. It just depends on the issue that's being selected to address. Can be maximum medical improvement, impairment rating. It just depends on the issues. There is a form that's filled out to select these specific designated doctor exams for the doctor to address. Now, the required medical exam doctor, now this is an insurance carrier select doctor, and these doctors are asked to address the same issues that the designated doctor addressed to see what the required medical exam doctor's opinion is based on the same issues that the designated doctor addressed. So ultimately, they're both able to address the same issues, but they're doing it in two different scenarios. And again, one's a designated doctor, state selected doctor, and then the required medical exam doctor is insurance carrier selected.
Hi, thanks for the info. I'm a provider side dealing with workers' compensation claims. Where do adjusters come in the equation? We do have a shortage in adjusters. We have a shortage in adjusters, and I have such a hard time getting a hold of adjusters. So yes, Dr. Dennis, I do understand sometimes it's very hard to get a hold of adjusters. I understand they have a very high caseload, but when it comes to a workers' compensation claim, now there are timeframes that adjusters also have to return calls, and that's 5 days. So 5 business days to return calls to get back with the requester, who the injured employee. Um, to be able to reach back and provide an answer. But if you do have any issues like that, or any claim participant is having any issues where they can't reach adjusters, which is one of the major complaints, they can give us a call at that 1-800 number. And we here at the division, as a customer service agency, and because we are a regulatory agency, we do assist with trying to get a hold of these adjusters. And then of course keep tabs that, hey, it's been more than 5 days, you have a certain time frame to return calls. We really, really, really want to emphasize the importance of communicating and the importance of being able to get a hold of the adjusters to discuss claims. So any issues like that, if you're exceeding that waiting time frame, you can always give us a call here at the division, and rest assured we will attempt to get a hold of the adjusters, or maybe a supervisor or something like that, where we can get you the help that you need. What form is required to apply for LIVs? So there's actually not a form to apply for lifetime income benefits. That in order to apply for lifetime income benefits, it must be done in writing, and it's submitted to the insurance carrier. So it's directly in writing to the insurance company. Let's see. Let me see. Question. I was advised by an attorney that 30 days begins the date after the date of injury for late reporting. Not sure as far as for late reporting, but the injured employee does have the 30 days to report the injury to their employer, to let them know that they sustained from, when they become aware that they've sustained an injury or an illness that's work related. So the injured employee must do so within those 30 days. Does the impairment income benefits considered additional income benefits, or do they solely make the employee whole in terms of their paycheck? In other words, are the impairment ratings benefits extra money? Okay, so the impairment income benefits, the injured employee can be working and receive their impairment income benefits. So these are paid based on the injured employee's impairment rating, if they have one. So this is money they're entitled to because the injured employee has an impairment. And so it's not, I don't want to say it's extra money, but it is money they're entitled to if the injured employee has an impairment rating. And they may be assessed an impairment rating and be back to work already. And during that time frame, they go to an exam, maybe a designated doctor, and they assess them an impairment rating, then they're still entitled to that money, because it is part of their injury and their impairment rating. So not really extra money, but they are able to receive that. They do receive that even if they're back to work. It's an entitlement based on their impairment. Says, when issuing impairment income benefits, does the weekly payment start with maximum medical improvement date, or when the designated doctor did the exam and gave the rating? If back pay, let's say MMI date in March and exam in July, can we pay a lump sum to start weekly from the designated doctor exam date? Okay, yeah. So impairment income benefits, the way that the law is written, they start the date after the injured employee reaches maximum medical improvement. And in a lot of instances, yes, there are the maximum medical improvement date gets backdated. So yes, like you said, March, and then the exam was in July. So yes, the insurance carrier would back pay the money that was owed from March to July and then continue from there on. So yes, those usually get paid as a lump sum. They're paid as a lump sum to the injured employee, and from there forward, they're the weekly benefit. Of course, if that's what the injured employee chooses. I know a lot of times they can request just the entire payment as a lump sum, and some do. But there's a form to do that. But yes, just kind of what you said. issue the lump sum from what was owed from the before to the date of the exam, and then from there on continue to pay the weekly impairment income benefit. Okay. Why is there a maximum amount of tips and the length of benefits that can be paid? Well, I mean, it's statutory time frame that they have. The life of a claim in general for workers' compensation is 7 years. So of course, the goal is to for the injured employees to be able to either return to work, to get better. We know that a lot of times that's not the situation, and they might not be able to return to work. And so there's other type of benefits that they may apply for in that case. Especially with those high impairment ratings like supplemental income benefit. But, that's the way it's written in the Texas Administrative Code and the Texas Labor Code, where, there's a certain cap for the benefits that they can receive for each of the type of benefits. And again, they're different for all. But unfortunately, that's how they have it. They have statutory dates and maximum amounts that they can receive. Let's see. So what happens if an employee reports an injury past the 30-day time frame? So the injured employee may report the injury past the 30-day time frame. As an employer, you'd still be required to report that claim, that injury. Now, why the injured employee? Of course, that's something that'll be investigated or looked at through the insurance carrier. What happened? Why did it take so long for the injured employee to report the claim? But ultimately, that's through the insurance carrier's decision or investigation process. As an employer, if the claim is reported after the 30-day time frame, the employer would still go ahead and due diligence and report the claim from the moment that you have those 8 days from the moment you were notified. Let's see. What if an employer? What if an employer has an existing supplemental carrier on hand and the supplemental insurance carrier conflicts with workers' compensation claim? Not sure if when you say has an existing supplemental carrier, you're talking about a personal health insurance carrier. I'm not, I guess we would need to get a little bit more clarification or maybe like a specific scenario. So if you can kind of send me that, what we're talking about exactly here. I can only think right now of if it's a personal insurance and a workers' comp insurance, there might be conflict. Kind of like the first question, if there's billing going to the personal insurance instead of the workers' comp insurance, then there's a conflict with the insurance carriers there. But if you have a very specific scenario, you can send that over to me and then we can look at it more in detail. Let me see. How do you handle claims where a causation is disputed? For example, a pre-existing condition aggravated by a work injury. So again, those are issues that are handled through the dispute resolution process. So I can't tell you how they're handled specifically. That would be more of a hearings question as to what they're asking for, what they need to dispute. But of course, there's of course re-aggravation of injuries, which may continue to fall under the same workers' comp claim, or is it a new injury and could open a whole new claim? So that's more of a hearings and how that dispute is handled realities. So I can definitely give you the information to maybe address it with hearings and get a little bit more information on how that would be handled and what they need for that dispute. But yeah, there are situations like that of re-aggravation of injuries. Let me see. Hi, are there any resources or guidance available for employers interested in becoming part of Texas Workers' Compensation Network? So yes, they're on our website. If you go under the tdi.texas.gov, sorry, you can go on there, and then I know if you were able to download our QR code, it has like the pamphlets and QR codes. It'll take you there too to our website. But there's a workers' compensation section, and then there's an employer section there just for employers. It's really neat. It has really good resources, and you might be able to start off there. If you can't or you find it a little bit harder, give us a call and we can guide you through it and kind of tell you what you need to do. But there are resources in there. So on the workers' comp tab under employers, you'd be able to find some good information there. Let me see. Is there a limitation on filing the claim? How long? Form from the date. Yeah, form. Yeah, from the I think it's form. Is there a limitation on the filing of the claim and how long from the date of injury does the injured employee have to report? So it's 30 days. The injured employee has 30 days to report the injury to the employer, and then they have 1 year to file the DWC Form 41, which is that form is filed with the Division of Workers' Compensation. And it's a form that gets filed with us, but to report it to their employer, again, it's 30 days. What are the deadlines for filing or reporting the claim? So again, for employers, you have 8 days to report the claim, the 30 days for the injured employee to report it to the employer. So does Texas have a state waiting days before time loss benefits would begin? To say maybe time loss, so I'm thinking of time of disability. So it's income benefits are I'm going to assume it's about when benefits start. So usually it's not as a state waiting period, but benefits usually begin on the 8th day of disability for injured workers. Again, it's 8th day of disability when it starts counting. And so not sure if that's the time loss, but if not, I can again address it through the email more specifically. How long does the employee have to be considered timely in the reporting of their injury? Again, they have 30 days to report it to the employer. Very important here. And remember, it's not up to the employer to make that decision. So as an employer, when you're notified that there is a workers' comp claim, and let's say it's been past the 30 days, but they're reporting an injury to you, that's information that you're going to report that claim to the insurance carrier. The carrier will do all the investigative work and see what took so long, why did they report it after, are they out of compliance, what happened there. But yes, employees, have 30 days to report their injury or illness to their employers. So how do we ensure true compliance when applying for supplemental income benefit quarterly and true job applications? And so for supplemental income benefits, when applying for supplemental income benefits, injured employees are required to submit proof of those applications that they've submitted. So more than anything, looking for those job applications and that the proof is attached as part of the application. Request, can you or will you do a presentation on the DWC Form 003 and how to accurately fill it out? We have so many employers that want to send payroll numbers and have adjusters fill it out. They don't understand. Oh, I left. My question's gone. Okay. But yes, on the DWC Form 003, we actually have a very specific presentation that's available. It's on our website under CompCourses. If you go on the Workers' Compensation tab, again, tdi.texas.gov. It's on there. You'll find it under CompCourses under the previous presentations that passed. There's one specifically just for wage statements only. Focuses on wage statements, the types of wage statements, and I think that'll be really, really, really good for you and for your company. So if you want to check that one out. We are out of time. I know we're a minute over, and y'all have things to do, so I'm going to wrap it up. Thank you so much for joining us today. If I didn't get to your question, and I know there's still a lot in the Q&A, please feel free to reach out to me. My name is Stephanie Saldana. My email address, I'll give you my email address, or you can also send these over to our DWC events so we can answer them, and they'll get those questions to me, and I'll get back to you. It is Stephanie, STEPHANIE .Saldana, that's SALDANA, at TDI.Texas spelled out .gov. So again, Stephanie.Saldana at TDI.Texas.gov. And if you could please just take the short survey that pops up at the end of this presentation. These really help us with the webinars and make them the best that we can. Thank you again so much, and you all have a great day.